Hello, this is Soumya Verma. Today I'll be teaching you Indian Evidence Act 1872 from section 1 to 4. The term evidence, as you all know, means anything by which any alleged matter of fact is either established or disproved. Anything that makes the thing in question evident to the court is evidence, where the question is whether an explosion took place before a fire occurred. The noise of the explosion and its flash are evidence of it. Section 1. Short title and extent. This act may be called the Indian Evidence Act 1872. It is applicable to all the judicial proceedings but not to the affidavits and the proceedings before an arbitrator. Section 3 is the interpretation clause where court has been defined as including all judges and magistrates, all persons legally authorized to take evidence except arbitrators. Here, fact is also defined. It is defined as anything, state of things, or relation of things capable of being perceived by the senses. Any mental condition of which any person is conscious. So, when we talk about facts, fact could be anything, any state of thing, or any mental condition of which a person is conscious. Law has not merely to deal with things physical, but also with the things which are so hidden as to beyond physical observation, just like person's mind, or intention, or negligence. Illustrations about what things are called facts. So a man heard or saw something. When a man sees something, this is a fact. When a man utter a word, this is called a fact. When a man holds certain opinion or intention, this is fact. Now, meaning of relevant under section 3. One fact is said to be relevant to another when it is connected with the other in ways referred in this act relating to relevancy of facts. The provisions relating to relevancy of facts are given under section 6 to 55 of Indian Evidence Act. Fact in issue under section 3. Fact in issue means the expression which either by itself or in connection with other facts, the existence, non existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. Its illustration includes A is an accused of the murder of B. At his trial, the following facts may be in issue like A caused B's death, A intended to cause B's death, A had received grave and sudden provocation from B. A, at the time of doing act which caused B's death, was by reason of unsoundness of mind incapable of knowing its nature. So, the requirement that a fact in dispute will be regarded as a fact in issue only if the fact is such that by itself or in connection with other facts it is crucial to the question of right or inability to show that there are two things to a fact in issue. The first is obvious and simple, namely, the fact should be in dispute between the parties. The second requirement is that the fact should touch the question of right or liability. Document has been defined under Section 3 of the Act as any matter expressed or described upon any substance by means of letters, figures, or marks intended to be used for recording that matter or may be used for recording that matter. Evidence has been defined under Section 3 as all those statements which court permits requires to be made before it by witnesses in relation to matters of fact under inquiry, all documents including electronic records produced for inspection of court. Now, the definition of terms proved, disproved, and not proved. Proved means when the court either believes into a fact to exist or not to exist. It depends on the prudent man ought to act upon the supposition that it exists, and the term disprove means when the court either believes it and it does not exist or consider its non-existence so probable that a prudent man ought to act upon the supposition that it does not exist. Not proved means when it is neither proved nor disproved. Section 4 contains the provision regarding the definition of may presume, shall presume, and conclusive proof. May presume means regard such facts as proved unless it is disproved. Shall presume means shall regard a fact as proved until it is disproved. Conclusive proof means the court shall not allow any evidence to be given for disproving any fact. In the next lecture, we will discuss Section 5 of Indian Evidence Act. Thank you.